Hello, class. My name is Faith Hirschi, and I'll be presenting Topic 7 with you today. This section is on competence to be executed and to participate in and waive appeals. I broke it down to the ABCs and the 1, 2, 3s. There will be 3 main topics and 3 main points. The topics are the American Bar Association and the American Psychological Association, A. B, think Brodsky inquiries, okay? C, think Constitution. When we talk about 1, 2, 3, there are going to be 3 main points that I will be covering for each topic that I just mentioned. So 1, and I won't go into each one for timing, 2, and 3. So this topic here is A1, which is the American Bar Association and the American Psychological Association, the legal test, right? If you want to follow along, that's on page 189 to 191. So the American Bar Association and the American Psychological Association has proposed a broader standard for what it means to be found competent to be executed in a resolution calling for exemption from capital punishment of any individual who has a mental disorder or a disability that significantly impairs his or her capacity to understand the nature and purpose of the punishment or to appreciate the reason for its imposition. The drafters of the ABA, which is the American Bar Association, resolution reasoned that if, as many commentators have argued, the primary purpose of the competence to be executed requirement is retribution, then the offender should not merely have a shallow understanding of why he or she is being executed, but rather should internalize why society has decided to impose the ultimate punishment. Now, this is a direct quote from the textbook that's on page 292 on to 293. Let's talk about the Eighth Amendment. The U.S. Supreme Court has ruled that the Eighth Amendment ban on cruel and unusual punishment bars the execution of an inmate with dementia if he is unable to form a rational understanding of the reasons for his death sentence. Some defendants are so mentally ill as to lack all understanding of their crime and its consequences and may be considered mentally incompetent. Such individuals may be unfit to stand trial or be found not guilty by reason of insanity. If they are convicted and become incompetent while on death row, they cannot be executed under earlier court precedents. However, most people with mental illness today, including many with severe mental illness, are not mentally incompetent. Let's look at the Scott Panetti case. So this is the first media source I want to share with you. This media source focuses on the reason that Mr. Panetti is back on death row. There are 3 major areas of concern. First, Scott Panetti's primary diagnosis is schizophrenia. It has been clearly shown that Mr. Panetti suffers from a severe and persistent mental illness. 2, Mr. Panetti's diagnosed symptoms include delusions of persecution that prevent him from mounting a solid defense against his sentence of execution. 3, Texas is following a narrow interpretation of the law, stating that the prisoner must prove they are incompetent. Mr. Panetti is first presumed to be competent, regardless of past or present diagnosis. And this is a link to a great article that I think you guys will really enjoy if you have time to read that. So moving on, we're going to talk about B, Brodsky's inquiries, okay? Or the evaluation issues if you want to follow along. It's on page 191 to 194, Chapter 7. In this section titled Evaluation Issues, Brodsky points out three major concerns with death penalty evaluations. Number one, numerous concerns with this type of determination for competence, right? So number two is a serious area of concern is voluntary inmates that waive appeals to prevent long-term stays on death row. So do you understand what that means? Like, so can an inmate competently waive appeals in an almost suicidal gesture because they don't want to stay all this long on death row? Number three, it is important for examiners to focus on the cognitive functions of the examinee. The Panetti ruling made it clear that the inmate must understand why society is imposing the ultimate punishment. Now let's look at number two, which is Ebert's competency to be executed rating instrument. Apologize if I messed up his name. This rating instrument actually focuses on 12 areas, but 8 of the areas actually focus on functional abilities of the examinee, and 4 focus on the clinical inquiries. There's limitations due to the lack of the sample questions for all 12 areas of attention, leaving the questions up to interpretation by the examiner. And number 3, we're looking at the interview checklist for evaluations of competency for execution. This one goes more into depth than Ebert's instrument. Now, for reference, if you could go to see table 7.1, chapter 7, our textbook, it's on page 193. So the checklist is actually divided into 4 sections. Number 1, understanding the reason for punishment. Number 2, understanding the punishment. Number 3, appreciation and reasoning, in addition to simple factual understanding. And number 4, the ability to assist the attorney. So these 4 sections are representative of the legal criteria for competency for execution that have been set out in various jurisdictions, but not all. Now we're going to talk about C. C is not for cookie. C is for Constitution, or the treatment issues, right? And that's on page 194 to 195 in chapter 7 of our textbook. There are 3 main points I want to make on this, and that is the treatment issues, the forced medication, and Charles Singleton case, okay? And so when we're talking about this, real quick, let me get my place. Okay. On February the 10th, excuse me, on February 10th, 2003, the United States Court of Appeals for the 8th Circuit voted to permit the state of Arkansas to forcibly administer antipsychotic medication to Charles Singleton. He was a mentally ill death row inmate, just to render him competent for execution. 8 months later, the United States Supreme Court did not accept the case, thus allowing the 8th Circuit decision to stand. Singleton's case highlights the complexity of medicating death row inmates. So let's talk about Charles Singleton's case. I'm going to talk about that on the next slide. This is the Charles Singleton case, and this is another media source that I'd like you guys to look at. It is a sad case, but it highlights some of the issues within our Constitution regarding mentally ill. Charles Singleton was on death row and had a forced medication order to alleviate his psychosis. The 8th Circuit Court found that the medical benefit of the medication order was primarily to alleviate his psychosis. The implementation of Mr. Singleton's death sentence was secondary to his need for medication to treat the psychosis. So Mr. Singleton was treated for psychosis and was executed on January 6, 2004. So the federal law was not clarified in this issue. The summarized findings in this case of Singleton versus Norris is that if a forced medication order for safety was standing prior to the setting of an execution date, the order will still stand. The Supreme Court of the United States did not take up the case due to Mr. Singleton voluntarily accepting his medication. Here are my discussion questions for you. How can the government interests and the defendant's rights be balanced when mental stability is an issue? Should defendants be forcibly medicated in order to be found competent to be executed? Why or why not? And what are the legal ramifications of your decision? Let me know your thoughts. I look forward to hearing your answers. And don't forget to rate my presentation. And I apologize for going over on my time, but just remember I am a country girl and I talk slow. So thank you all for listening to my presentation. I hope you have a wonderful day and I appreciate your time. Have a great day.